কোনো ক্ষেত্রে নেই কিন্তু maybe short that the different
Adjournment request, if any, from item number 1 to 6.
Yes.
Item number 4, I am seeking an adjournment on behalf of the respondent department, Your Lordship.
Have you informed the council for the?
I'm there for
appellant?
that.
Yes, I will inform the other side, Your Lordship.
The letter comes, prayer for adjournment has been made on behalf of the respondent after obtaining no consent, after obtaining consent from the council for the appellant. Re-notify sometimes in January.
Oblige.
Oblige, Lordship.
27 January.
Oblige.
Wait, please, Your Lordship. I beg to mention item number 3 with the concern.
Louder.
I beg to mention item number 3, Lordship, with the concern of the respondent council, Lordship.
Number 3,
Number 3, Lordship. I'm praying that matter will be listed after 2 weeks, Lordship.
why?
We want to file additional affidavit, Lordship.
Regarding what?
In the IA, Lordship.
Regarding what?
Regarding explaining delay, Lordship. Some part we could not explain the main affidavit.
Anyway, as you wish. You are for the applicant,
Appellants, Lordship.
appellant applicant.
Yes, Lord.
Yeah, a prayer for adjournment has been made on behalf of appellant/applicant for bringing in additional affidavit explaining the reasons for the delay in preferring the appeal. The prayer is acceded to. Let this matter come up for consideration on your date sometimes in December. Yes,
Also, good.
8 December.
Wait, please, Your Lordship. Lordship, I beg to mention item number 5, Lordship.
adjournment slip has been circulated with the consent of the other side. Re-notify on so date.
Lords, can I get a date on 20th of November, my lords? Or 26th of November, my lords?
Lordship, maybe
26th of November.
24th of November.
Just 24th is very good. 26th of November. We can.
26th November, please, my lords.
All right, 26th.
Yes, my lords. It's a law day also, so Constitution Day. Please, my lords.
All right. There can be no consideration for fixing a date.
No, no, my lords, it would be a pleasure to celebrate it in
So
Guwahati.
far as the disposal of cases are concerned.
My lords, it would be a pleasure to celebrate it in Guwahati, my lords. That's the reason why. I said so.
That's your reason. That's not. the
Yes,
reason.
madam. That's my personal interest, madam.
All right.
Obliged, my lords. Obliged.
If the counsel for the appellant will have some objection, we don't know.
Lordship, I was suggesting 24th of November.
24th would be difficult for the bench.
Oh, yes, Lordship.
So 26th, if you're very uncomfortable that day, make a mention, we will adjourn it for another day or something.
Yes, yes.
Well, it's ample opportunity they've got. Actually, they were supposed to get back with regard to taking opinion from their client, whether they can settle this matter. They've already taken 2 dates on that ground.
Let's see. Let's
Please,
see.
my lords. Please, my lords.
Obliged.
Thank you. Obliged, my lords.
From item number 7 to 21, adjournment request.
As regard item number 11, Your Lordship,
Yes,
matter has become infructuous, Your Lordship.
very good.
My
This is the coal mine bidding.
Lord, because of the order passed in interlocutory application, my lord,
Again,
nothing surviving.
the land counsel for the appellant submits that this appeal has become infructuous. He therefore wishes to withdraw the same. Dismissed as having, this appeal is dismissed as having become infructuous. Yes,
Deep, Your Lord.
I like to mention item number 19, madam.
19.
19, madam.
Yes,
This matter may not be taken up today, madam, because madam, the briefing speech Mr. Rana Council as the process, who is out of station on account of death of his one of the relatives, madam.
item number 19. All right, so, but we can't guarantee you tomorrow. This will have to go to another date.
My lord, after a week, my lord.
A prayer for adjournment has been made on behalf of the written petitioner. Re-notify on whichever date is available. Yes,
How are you?
24th November.
How are you?
May I please, your lordship, I beg to mention for listing one urgent matter.
No, let us first see whether any adjournment motion is to be.
Adjournment request from item number 22 to 27 to 31.
May I please? I'm praying for an adjournment in item number 27 for the personal,
27.
my lords. The personal difficulty of the conducting council. my lords. Has to-
Have you informed the other
I
side?
have informed, taken the consent of the other side.
A prayer for adjournment has been made on behalf of the petitioner after having taken consent from the council for the respondents. So pre-notify January.
My lord, also in item number 28, it is wrongly tagged. This is a single bench matter, my lord.
Let's see, let it
Well,
come on the date, we'll see.
28th January.
April.
May it please your lordship.
Yes.
To mention item number 26, lordship. There I may pay. lordship.
26,
Your
you
lordship.
cannot have it like this, no?
Yes. it's
Unless,
tag
unless,
matter.
unless you have taken consent in item number 25.
25. Lordship.
What lordship? You have taken consent.
I'll take consent because
You first take consent and then come back to us.
obliged lordship.
This is with respect to stamp vendors.
Stamp vendors, here I want to find my reply lordship. to sort
All right, you
explanation.
inform the other side
I've taken consent of the.
for item number 25 also.
No,
Take consent in item number 25, then we grant you adjournment.
lordship.
All right.
For item number 29, with the consent of the other side, I'm praying for an adjournment.
29,
Yes, lordship.
May fix melody. Fix a date after 2 weeks because he's bereaved man melody. War is bereavement, that's it.
Senior is in bereavement, lordship. That's the reason.
huh? We are not asking for any reason, no? You are for the respondent.
Yes, lordship.
As prayed for on behalf of the respondent and agreed to by the council for the appellant. Mr. Chaudhary is appearing in this matter.
Yes, I think that the other side is.
All right, let this matter come up for consideration on so and so date.
Obliged, lordship.
15 December.
A date may be.
15 December.
Lordship, in item number 30, Lordship, I require 2 weeks' time to file my rejoinder, Your Lordship.
Item number 30.
30, Lordship.
If you do like this, we will be left with no case. Huh? Then we'll have to ask for further round of cases. But today, item number 30, as prayed for on behalf of the appellant, writ petitioner. Re-notify on so and so date. Yes.
First
you're in
of
the same
December.
matter.
Item number 22.
Item number
Number,
22.
22.
what do you want? 22?
We are waiting for the instruction, so we want to list
On
it,
behalf of?
Gunjan Bordeloi, G Bordeloi.
Property department.
This
As-
for respondent, my lord, I am.
Have you informed the council for the appellant?
Yes, I am. my lord.
As prayed for on behalf of the respondent after having obtained consent from the council for the appellant.
No.
Let this matter come up for consideration on so and so date, January.
May I please?
9 January.
Obliged, your lordship.
I'm praying for listing of case. my lordship. I'm selected for admission in MBBS course in.
Louder, we can't hear you. We can't hear you.
Have been selected for MBBS course in Guwahati Medical College
That's right.
under PWD quota, but I filed the petition. Honorable single judge has issued notice but declined to pass interim order. The last.
No, what has happened? You have been selected.
Yes, my lord.
Then what is the purpose of filing the writ petition?
Because when I appeared for verification of my certificate as per the instructions, so my provisional admission has been cancelled.
Why? Your PWD certificate is
Yes,
incorrect.
Yes. It
It's
is
incorrect.
Intact.
Supposed to be forged.
No, my lordship.
Then
They said that in the morning I appeared. In the evening, a medical board has given a conclusion that I have 18% disability without without following the principle of natural justice and without examination of my health, my lordship. Thirty-first is the last date of admission.
Today is 29. Keep it on 31st.
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 31st is the last date, my lordship, of admission, my lordship. My prayer in the writ petition was that one
Seat should be kept reserved.
Yes, my lordship.
That we can do 30th. Come on.
Highly obliged, my lord.
May I please, Your Lordship? I beg for listing of a writ petition, Your Lordship. There is a writ appeal on Friday. It is fixed on Friday before this court. It is regarding the appointment of TEP teachers, Your Lordship. Similar matter has been there in court number 19 where stay is already there. So it may be called up for disposal
You
together.
remind us on that day, we will do it. Otherwise, we'll not call for cases which is listed before single judges. Only when it is required, we'll do that.
Much obliged.
Remind us on that date.
Much obliged.
Any other request? Daily list for orders item 1.
Yes.
For restoration of the electric connection in the use of Nagar Samiti Lodge.
Now, what has been done pursuant to the order?
My lords, pursuant to the order, my lords, because the application, my lords, first was made by the secretary of the committee, my lords. Now the electricity connection has to be given to individuals, my lord. We had asked them, there's a letter, my lord, we filed an affidavit to that.
No, is the writ petition finally disposed of?
No, my lords, it's pending.
It has not been finally disposed of.
It is tagged with a pending PIL, my lord, PIL number 27 of 2013.
The order was passed in the PIL or in the writ
In the
petition?
writ petition, my lord, it was tagged with the PIL.
No, it is a forest reserve, no?
Yes, my lords,
Amchang Reserve Forest.
yes.
Now, how can that be done?
No, Lordship, that earlier there was a notification to that regard. It was a revenue village, Lordship. And subsequently, they have created and that,
Have you
that
taken?
demarcation has not yet been completed.
Have you taken a plea that this is not possible to be executed?
My lords, what has happened, my lord, during the
We
eviction,
are asking you for a simple question. What has happened? We understand.
my lord.
You tell us whether you have taken any plea that this order is not capable of being implemented because there are other orders running,
Yes.
which has its force that reserve forest area should not be used for habitation.
My lord. That
Have you done
plea,
that?
my lords, respectfully, my lord, that plea hasn't been taken.
Do something,
My
no?
lord,
Purge
what-
yourself of the contempt.
Well, what perhaps might be important is, my lord, during the eviction drive, my lords, the entire electrical infrastructure was dismantled, my lords. Now, for us to restore connection on a temporary basis, my lords, we have also given them an estimate, my lords. That is part of our affidavit. Because the APDCL had not participated in the,
Take this plea. This is a very naive plea. What is the purpose of giving the estimate?
because the persons who
You
are,
don't expect the state or the electricity company to be reimbursed.
my lords,
If you have
we'll have
wrongly
to,
dismantled the electric connection,
my lord, we had not, my lord, the district administration, my lord, respect.
I don't think you're understanding what the court
My
is
lord.
wanting you to answer. The difficulty is this.
My lord.
Now, the writ court passed an interim order
Yes.
that till the time the petition is dismissed or allowed,
Yes.
till it is disposed of, you restore the electric connection.
On a temporary.
Now, it is not for you to say that it'll entail costs because individual connections have to be restored. You can't take that plea, especially when the interim order has not been challenged.
My lord,
Don't you understand this?
my lord.
You're in clear contempt. The order was passed long time back.
We communicated to the, my lords, then my lords will allow me to file an additional affidavit, my lord.
File an affidavit. But in the meantime, you can't, make them live in dark. You can't allow them to live in dark. Either you say that they are encroachers, they are squatters, they can't be regularized there as residents,
My lord.
or you do what the single judge has said. Have you made any attempts to have that writ petition come on board and be argued?
The writ
Nothing.
petition,
So you're sitting over that interim order.
the writ petition, my lord, is tagged with the pending PIL. my lord.
Have you made any prayer before this court? Because this court only deals with PILs.
Yes, my lord. The PIL, my lords, was adjourned for a period of 3 months because the concerned authorities, my lords, are now working out.
When is it likely to be listed?
My lords, it was last listed in the month of April or May, my lords. It was adjourned for 3 months, my lords.
No, 3 months adjournment was given in January.
My lords, in May, I believe, my lords. I'll
May,
check
June,
it,
July, August. Okay, I think it should be listed. Let this matter be listed.
my lords.
along with PIL number
27 of
Seven of
2013.
13.
27 of 2013 on give a date in November end.
Deeply blessed.
You have to tell us, no. One, you must say that this contempt petition, the order has not been passed in PIL. So they should also make a prayer that PIL should be detached, PIL would be taken up.
Yes.
This is an interim order, you have not challenged it.
My lord.
You have not challenged it.
No, ma'am.
You have not asked for vacation of that order.
No, my lord.
Then,
Yes, ma'am.
and we are not going to suggest you to do that.
Yes.
And you are giving an estimate. Is that a correct ground? If at all we would like to have our orders enforced, you can't, transfer or saddle them with the cost. You have to restore it, howsoever expensive it may turn out to be.
My lord. But the individual connections, that would be necessary, my lord. But leaving aside the cost part, my lord, the connections, perhaps, my lord.
How are we concerned?
My lord.
You have to follow the order,
Yes.
or you have to have the order vacated,
We
modified,
we
decided.
have communicated to them, my lord. They have not responded, my lord.
Again, you're not understanding. No
Yes.
matter, how much lung power would I use? Communication to them is not our concern.
Yes.
You were required, if that was not possible to be executed,
Yes.
you could have filed an application for an early hearing of the writ petition.
Right.
Or for modification, rescinding of the order, something.
My lord.
You think we are advising you for all this? What communication have you made to the petitioners? That you will have to, if you pay the cost, we will restore.
Individual applications, my lord. Only to that extent. my lord.
I'm surprised. I'm surprised at this naivety, at this naivetes rather. Therefore you accept it, that it has to be restored.
But the restoration,
And then perhaps your estimate has got nothing to do with the petitioners, nor with us.
Oh.
Think about it and then make an argument. We are having it for your convenience. We are having it listed along with the PIL.
my lords.
All right.
Deeply blessed.
Until such time, if you keep them in dark, we will also settle you with cost.
My lords.
You have not done anything to have that order modified. Who leads you in this matter?
I'm also a standing counsel for the company.
You're also a standing counsel. So have you understood what
Yes,
this
yes.
is telling you?
Yes, my lord.
And when was the interim order passed?
It was in 2023.
No, 24.
22, I'm sorry.
3 years have passed.
Yes.
Yes.
What is there to explain the contempt? To purge you of the contempt? You're in clear contempt. And who is the answering respondent?
The concern, my lord, SDV, my lord.
We'll have to have him here.
My lords, on the next date, my lord, I'll place everything on record.
You understand the
Yes,
seriousness of it only after we have spoken so much.
My lord.
All right, along with the PIL.
And deeply blessed.
Please apply your mind before addressing the court.
No.
Correct?
No.
Yes, next.
On 28/11. Item number 2.
In this case,
Report has come.
we have taken a step, my lord, but party, I think. Twice we have taken a step, my lord.
Twice you have taken steps.
My lord,
No fresh steps has been taken.
my lord, we have taken on 26th, 2025.
No, our report dated 2/9/2025 says no fresh steps have been taken.
We'll take, my lord, then.
First you say that you have taken, then you say you will take.
My lord, earlier 2 times we have taken, my lord, steps.
Pursuant to the order dated 9/5/2025, have you taken steps?
Sorry, my lord, I will take, my lord. Tomorrow itself, my lord.
So take note. It appears that the address of the respondent number 2 provided by the appellants is not correct. And therefore, respondent number 2 could not be served. Let fresh steps be taken for serving of notice, for issuance of notice to respondent number 2, including furnishing of correct and present address, including furnishing of his correct and present steps. The requisites shall be filed within a period of 1 week.
Well.
Whereafter the notices by both boards shall be issued to respondent number 2. Returnable on January.
19 January. Item number 6.
My lord, delay of 4 days, my lord.
Which
Fine,
item?
okay.
We condone the delay. Delay is condoned. The appeal is to be processed.
Great.
Pura detail लिख देना. Delay of 4 days in respect to the appeal.
21st January. Item number 7.
Yes, Mr. Bora.
My lord, I have received a communication from the department. Now they have taking steps in it.
No, Lord, we welcome this step they have taken, but my order of the trial court is of October 2023. So I'll pay 11,000, my lord, subject to further orders that your lordship may pass. I should be permitted to register my probate proceedings.
Correct.
Only problem, my lord, is the committee
What
is
is
to.
the problem? You should have done that. no?
Committee is to constitute and again it will
He
place
is
before the
objecting to
cabinet.
it. He says that till the time temporarily he will pay 11,000.
My lord.
Take that.
my lord.
Mr. Bora, Mr. R.K. Bora, learned additional senior government administrator, has furnished a communication dated 27/10/2025 by the ACS Revenue and DM Department across the board, which has been accepted, which has been taken on record. Pursuant to the orders passed by this court, steps have been taken to constitute a committee for amendment of the Court Fee Act 1870. Stop. The communication further discloses that after the constitution of the committee, the department will take necessary action for expeditious amendments / modification of the act of the said act. Stop. Considering the aforenoted submissions of Mr. Bora, we direct that in the meantime, the petitioner shall be made to deposit only rupees 11,000 as court fee, but that would be subject to the final outcomes of this petition.
Yes, I am reviewing.
Item number 8.
There is a delay of 221 days in preferring the
Notice,
notice.
all government. All respondents are all government officers.
My lord.
Respondents are government officers, Mr. Chaudhary. Yes, what do you have to say?
Lordship, we have no objection to the delay.
Like, there's an application seeking condonation of delay of so many days in preferring this appeal here, preferring this appeal. The Land Council for the respondent, however, offers no objection to such a prayer. We have gone through the reasons provided in the application seeking condonation of delay. Finding it to be good grounds, finding it to be good reasons, we condone the delay. The application is allowed, the appeal to be processed and be listed preferably on solicited.
Okay.
5th of January. Item number 9.
May I please your lordship, as per office note 24/10/2025 lordship, steps on respondent number 4 is still awaited lordship. We may be allowed to take fresh steps lordship.
No, it is awaited, so we will wait for it. Have they reported anything? Now, why do you spend money there? Awaiting the service of notice on, awaiting the report regarding service of notice on.
24/10 lordship, office.
Respond number 4, the matter is adjourned to give a date in November. Then we will allow you to take fresh steps.
Much obliged.
Oh, then. It's okay. So, let's. then-
17 November.
Much obliged.
Just a minute. In order to cut short the matter, let me do it. Again, the response number 4 has not yet been served. Let fresh notice be issued to respond number 4 on steps being taken by the appellant, the appellant within a period of 1 week, both modes returnable on. You have a date. The writ petitioner.
1st of December.
Much
One
obliged, Lordship.
Supplementary list for orders item 32.
Medicine supplement.
Yeah, please, Your Lordship. As per last office note dated 28/8, Lordship, services upon respondent number 4 and 5 has not been completed.
Awaiting the service of notice and a report regarding the same. As against respondent number 4 and 5, the matter is adjourned to November 12th date.
Deeply missed.
Give the date.
Yes. 27 November.
Deeply missed.
Daily list for admission item 10.
But similar matters, your lordships has already passed order. My lord, I have given the copy. আপনি appear করবো? This has come for the first time, my lord.
Let notice be issued. You appear.
My lord, only thing is that while passing that earlier order, the order of the Honorable Supreme Court was not brought to your lordship notice, my lord.
No, that's right. So you appeared for the respondent.
Yes, ma'am. I appear
The
for the
learned counsel
respondent.
for the learned counsel for the appellant, as also the respondent is present. Let this matter come up for consideration along with WA number 165 of 2025, which is slated to be listed on 27/10. It's over. No?
No, my lord.
10th of December.
10th of December.
Slated to be listed on 10th of December, 2025. Stop. In the meantime, the effect and operation of the impugned order shall remain state.
My lord,
My lord,
highly obliged.
See, the matter has been decided. You are a pre-April retiree, pre-1st of April retiree.
that is decided by the division bench, and the order of division bench has been already assigned before the Honorable Supreme Court. where
We are aware of that. So Supreme Court says that no interference with the order of the division bench, just that recovery shall not be made from you.
Yes,
So we will pass that order later. Let's see.
yes, my lord, but in the meanwhile, if they, my lord, recover in our case, my lord.
No, don't.
No, there is no contemplation, my lord. There is no in fact, they have already got, my lord.
Yes.
Much obliged.
Deeply.
Item number 12.
Here, let this case go out of our list and be placed before an appropriate bench of which one of us, bracket mein Arun Dev Chaudhary Che, is not a part. Stop. List this case, place this case before the Chief Justice for allocating an appropriate bench.
Item number 13.
May I please, Your Lordships? Here we have challenged the common order dated 31/3/2023, my lord. This common order was also challenged in writ appeal number 185 of 2023, which was fixed for hearing in the month of September. So both the matters may be tagged along.
September is gone.
My lord, it was not listed. It was fixed but not listed in that month.
How many writ appeals have been filed?
I don't.
Prima facie, we don't find any fault with the judgment, but then it has to be argued.
Yes, ma'am.
You were not under the government service. There was no substantive appointment, no permanent appointment, therefore no pension. That period cannot be counted. Of course, there has been a delay on the part of the government. Let's see.
My lord, it may be tagged together.
That's right. How many writ appeals have been filed?
I don't have the list with me.
There are many writ appeals. Can you just find out for your advantage, how many writ writ appeals have been filed. So if we can have the date, we will bring all of them on record on one particular day and we will decide.
Yes, ma'am.
Can you do that today? No, you can't.
I'll try and check with my senior, my lord.
You'll check with your senior.
Yes.
The registry can, my court office can do that. All others are already taken. So list this appeal along with those on so and so date, give a date,
Yes.
sometimes in January, February, January.
Yes, February.
January and
Number দিব পারতো। একা দিলে হবে, একা number দিলে হবে।
sometimes in January and all
January.
units. एक ही दिन लगाएंगे तब सुनते हैं।
ठीक है बोलो।
Item number 14.
No, this is in respect of blacklisting, my lord.
Blacklisting. I don't think blacklisting. Let's see what's the order. Where's the order?
Before that, may I submit, my lord? This appeal is against the order, my lord, whereby the interim order has been rejected. The main writ petition is listed before court
That's
number
not
10.
right. So therefore he is challenging that, no interim order by the single judge. That's what he's challenging. So let's see whether he is correct.
Lordship. My lord, I
Where is the order of, where is the blacklisting order?
blacklisting order. My lord, at page 147 order.
Page 147.
Yes, no, I'm sorry, I'm sorry. Page 155. 155. 155.
Page 147. Yes. This is a show cause notice.
So 155 is the final order, my lord.
Show cause notice.
No,
The delay penalty, look,
this
read
is
the
the
last part.
this is the department order.
It's a department order.
Yes, 155.
No, it's not a department order.
Yes, my lord, page 156, your lordship, sir.
No, 148.
156, third para.
155.
156,
Just a
second para,
minute,
my lord.
Just a minute,
Therefore, in greater interest of.
just a minute.
Yes.
Therefore, the greater public and your company also is hereby blacklisted and debarred from participating. No, this time, look at, let us see the notice.
My lord. Notice is at, my lord, at page 147. My lord, notice is in respect of.
Can you read the last part
Yes,
at page 147? If
One-
you're
no,
challenging the.
148, my lord, the last, my lord, party portion is 148. Last one.
Hmm.
You are hereby asked to show cause.
You
Why?
can't build up your case on this,
Yes.
Mr. Counsel.
Yes.
If you're challenging an order of the learned single judge refusing to entertain your prayer for any interim protection,
Yes,
you need to read this part,
yes, yes, my lord.
para 147.
Yes, I am reading.
We are not here to build up
Hence-
your case.
Hence, in the greater in public interest, you are hereby asked to show cause why your product should not be debarred as per referred penal clause number so and so. Now penal clause has been mentioned. Debarment, blacklisting for failure to execution so and so, product debarment, where it is mentioned that in case of non-supply of incomplete supply of less than 90% of the total order quantity by the approved manufacturer firm within the agreed delivery period, including the delay penalty, such extended delivery, here then the concerned contract shall be cancelled and the manufacturer importer firm shall be debarred from participating in the bid so and so. But the show cause is in respect of my lord, why product should not be debarred. That clause has been quoted here.
Product has to be debarred. Not.
And finally, also 148, my lord, last para, you'll also see same thing, my lord.
Let's see the impugn order.
And I have, my lord, in the.
Just a minute. Yes, he can't be debarred from participating. That's not part of the notice.
No, Lordship will see, my lord, page 148. Thus I am placing, my lord. Page
Page 148.
148, yes, the second line, my lord, the end, at the end, Roman 2, my lord, farm debarment. The farm shall be blacklisted and debarred from participating in any tender in the TIA or procuring agency for 3 years if the company is debarred for all the.
Where is it? Where is it?
My lord, page 148, second line in the right hand side, my lord. Farm debarment, it is very categorically mentioned in the, my lord, so cause notice. That's why Learned Singular was not pleased to, my lord.
Just a
state-
minute. Read, the firm shall
The
be
firm,
blacklisted
the
in
firm shall be blacklisted and debarred from participating in any tender by the TIA or the procuring agency for 3 years if the company is debarred for all the items where it is rate contract for less than 3 items or at least 3 items where it holds rate contract for more than equal to 3 items. Also, as per the point number 3, that is forfeiture of performance security, but that is a different issue, my lord. So here, my lord, it has been found that, my lord, otherwise he has defaulted in supplying of medicine in more than 3 items, my lord. That's why finally, my lord, he was debarred, the entire farm was debarred, my lord. And it was categorically mentioned in the, my lord, so cause notice that not only, my lord, product debarment, the provision for farm debarment was also mentioned. Then Lordship will see page 149, my lord, where he has defaulted. The entire annexure A, my lord, chart,
And so against the rate contract,
my lord.
so he has defaulted in supplying less than, about
More than 3,
90% for more than 3 items.
More than 3 items. My lord, Lordship will see page 149 where he has defaulted, we have annexed it. It's part of the so cause. Page
Where is the
149.
final order of debarment?
Yes, sir. It is at page 155. From para 2, my lord, but you are not yet completed the required supply of essential drugs within the.
Where is the consideration of the grounds taken by him?
The Lordship will see, my lord, in the third para, all efforts as mentioned above via several notices, extension, official communications via so and so were made, enough scopes were given to your company to execute supplies of essential drugs. But
So that's all right, but what has he?
My lord, he has not even replied, my lord.
So you say that.
The effective reply has not been submitted, rather he paid for extension more, my lord. My lord, it was to be supplied within 30
He has not
days.
replied.
Not replied. my
Against
lord.
the notice, he has not replied.
No, my lord, he paid for extension of time in the, my lord, reply.
And what do you say that extension is not possible?
My lord, the period of supply is, my lord, 30 days. Lordship will see the tenure of, my lord, default. At page 149, some, my lord, 230 days, 33 days.
Then we finish up.
Medicine, my lord, there is a delay of 200 days, 150 days, my lord. That's why.
For how many items did you have a rate contract with him?
My lord, it's more than 50 items. In the affidavit, in the writ petition, we have, my lord, annexed that, sir. It's part of the writ petition, my lord. More than 50 items.
His file is in play, no? So they must. Why does he say that he has not replied? No, but where have you considered this explanation at page 151? You said he has not replied. He has.
No, replied, my lord, other.
Actually, you should be correct, no?
No, Lordship will see, my lord, in the next para.
No, we are asking you for 151 reply.
Yes, that is.
And
there.
asking you whether you considered that
Yes,
reply.
page 155, last para. The SML authority found that the said drugs are essential in nature for needy patients getting treatment in government hospital. Therefore, so cause notice was served to your company by so and so, whereas your unprofessional reply being a pharmaceutical company dealing with the essential life-saving drugs are not
All right.
justified enough.
All right. So you have to point out that each and every aspect
sorry,
would be necessary.
No, my lord will
Because
kindly.
it's a civil death of a contractor. You're debarring him, preventing him from participating for 3 years. Of course, that's within the charter.
Lordship.
But then we must know that you have considered his reply in the correct perspective. So that's an unprofessional thing because medicine supply is urgent.
My lord, 30 days, my lord, 200 days, my lord, there is a
Therefore-
delay.
Yes, what do you have to say?
I don't understand.
My lord, so far my learned friend has shown in the so-called notice, that is only
Mr.
clause has been quoted. That clause has been quoted, my lord.
Mr. Saiwala, we are inclined to close the writ petition also.
Yes.
We'll dismiss your writ petition also.
But-
Forget what.
Well.
You're inclined to.
Because
That's not
now,
Mr.
now,
Saiwala, you have not followed what I am suggesting to you. Don't press this appeal. Otherwise, we dismiss your writ petition also.
my lord, I am submitting, my lord.
You did not understand. Therefore, you said yes.
No, I could not follow that.
I'm saying this. Now, with this explanation and with this order, after having considered your explanation, we find that you don't have a case even to be heard by a learned single judge. We close your petition for all times to come. So don't press this.
My lord,
These are good advisories from the bench. Accept it.
no, your lordship may just see, my lord, what my learned friend submitted, that is not correct, my lord. Because in one so-called notice, my lord, that clause has been quoted only. They have not issued the so-called notice for blacklisting, my lord. They have issued the notice only product development.
No.
Yes, my lord. Your lordship may see again, my lord. That clause has been quoted.
Read the whole part of, it begins from hence in greater public interest.
The entire clause has been quoted, my lord. Entire clause has been quoted.
That's all right. So you are saying that the last part of the notice does not clarify
Yes,
that this is the action which he is supposed to take.
yes, my lord. That is the, my lord. Because that
That's
is,
an
clause may be there, my lord. Clause has been quoted in the 147, but
Argue this before the learned single judge.
my lord, and moreover, my lord, I have cited several decisions of the Supreme Court. Now they have developed that
What?
personal hearing must be given, my lord.
No,
Our
no,
High Court judgment is also there. No, I can place, my lord.
no.
I can place, my
That is personal hearing is not required if notice. Gorkha Securities.
No, Gorkha Security, after
Rules
that,
field.
after that also, my lord, the judgments are there.
No, there are many judgments, daffodils, Gorkha Securities, and there are many others which I can't,
No,
tell you.
I have, my lord, I have.
Personal hearing.
I have
Give
all
us
the-
that judgment.
I have all.
Give us that judgment.
I shall give, my lord. At least, my lord, or three Supreme Court judgment as well as our High Court judgments.
Give us Supreme Court judgment
The Supreme Court, yeah,
where a personal hearing is required.
my lord.
Yes, I now remember one case, Blue Dreams, DREAMZ.
Available, sir. This, my lord, three judgments are there.
By Justice Vishwanath.
In the sir, only. First case is of 89 and that has been proven later on. There are four.
This order will, however, not prevent the state government so entitled to do so according to the law. After giving, this is under the directions of the court, but not as a matter of requirement. These are individual cases where the court, suppose this court says that please hear him out. Give him a personal hearing, then pass that order. Now, of course, they'll be under an obligation to do that.
Your lordship.
But the law, has the law been changed?
My lord, yes, my lord. That State Bank of India, my lord, if your lordship see, para 60, 65 and 98.4. 98.4, your lordship may see, State Bank of, yes, my lord.
Daffodils, you're asking for daffodils.
No, daffodil is also there, paragraph 14, 15.
Which paragraph?
Paragraph 14, 15, my lord.
Paragraph?
15, paragraph 15 may be seen.
1.5.
Paragraph 15. Paragraph 15.
15 submissions are there. Which paragraph are you with?
No, last one, if there is one constant process that rights of judicial supervision in the country, in this case, no one can be inflicted with an adverse order without being afforded a minimal opportunity of hearing and prior.
Without being afforded a minimum opportunity of?
Hearing.
Where have you said so?
Huh, well,
Which paragraph? In which just
para 15,
of daffodils?
yes.
Hmm.
No one has. Okay.
Or no opportunity of hearing or a chance to represent against the impugned order. This one line you can't lift.
Then, my lord,
There is no reason for the law expounded in Gorkha Securities still holds the field. Personal hearing may not be necessary every time.
my lord, and this SBI case, my lord, also the last para your lawsuit is 98.4.
Argue before the learned single judge. We are not interfering. There is only a slender ground which we don't want to invoke in your favor. You are the last party.
No, my lord,
Just a minute. You are hereby requested to show cause why your product is on the depart as per referral. As per the referred penal clause of the tender and submit relevant supply to show cause from the date and upon non-submission. Those financial parties will be levied as per relevant tender clauses. These are.
Another fact is there, my lord. I applied for some extension and they issued a letter at page 144. Your losses may just see, my lord. This is a letter dated 10 February, the last para. Kindly resubmit your extension request by tomorrow by mentioning above information or onward submission to the MSCL authority for taking necessary decisions on your plea. Your request attached so and so and so. So we have paid for extension and they asked us to submit the extension letter with details next day. We submitted the same day, my lord, next page, 145. Same day we have submitted, madam. Because there was some translation mistake,
What
madam.
happened? No, we do assure you that all materials will be forward to is to consider Karnataka. Now, this request was made to you.
Yes.
This request was made by you pursuant to a communication
Yes.
made on 10/2.
Yes, 10/2. 10/2 on the same day, my lord, he asked us to next day, but on the same day I submitted.
On 17/2/2025, you were served with a notice.
No, before that, my lord, your lawsuit is 17, yes, 72 so called notice has been issued without considering this, my lord.
No, show cause notice was given to you for that consideration of this document is not necessary.
Yes.
After the show cause notice, if you have supplied, if you have given any reply.
My lord, that is, if your lawsuit see, my lord,
No,
my
just
reply.
a minute. After he also confused himself.
My
Now, after this notice of 17/2/2025,
Yes.
you asked for an extension.
My lord, that is, my lord, if your lawsuit see, my lord,
Your request for extension is prior to the notice.
yes, after that also page 154, my lord. 153, 154.
But within 15 years.
Oh, sorry, sir, my lord, I'm not that. My lord, in the. Sorry. My lord, that 19/2 letter, my lord.
19/2 letter is when?
At page 151, my lord. is very important, my lord, here. We have successfully completed so and so, and the remaining goods are currently in Guwahati. Now currently in Guwahati, my lord, because transporters, however, due to closure of the relevant purchase order, we are unable to deliver the pending items in this time. Regarding annexure so and so, we confirmed that 100% of the quantities were dispatched. Unfortunately, due to mishandling of the transporter, the remaining quantities were not delivered as intended. For annexure so and so, we dispatched 100% quantities. They are currently held in our transporter's warehouse at Guwahati. If we are granted an extension of the purchase order, we will dispatch the goods within 15 days. So and so. My lord. Well, goods received, my lord, in Guwahati, transporter office, my lord, because transporters some difficulty, my lord, it was delayed. And the so-called notice which they have shown, my lord, that is also wrong, my lord, annexure, many.
Let him participate in the tender.
No, there is no tender as on that matter.
No, let him participate in the tender. Depending, you float a tender for concluding a rate chart with anybody, let him do that.
Yes.
That part we. So it will not be vis measure. His case would not be covered by vis measure, or what is it? The other expression is act of God. There's no act of God, but he was not to be blamed.
No, but my lord, one thing, my lord, may I submit, my lord? All the supply orders are aware of September 2024.
He has been suffering.
Lordship may kindly consider this part, my lord. All are life-saving drugs, my
We
lord.
are not interfering with the department.
My lord.
That the single judge will decide.
My lord.
We are only saying that in case you float a tender for
During the pendency of the writ petition, my lord.
during dependency. Allow.
Now presently there is no such tender.
We have heard Mr. Sahewala, पूरा नाम क्या है इनका? Heard Mr. G.N. Sahewala, learned senior advocate for the appellant, and Mr. B. Gogoi.
My lord, for respondent 1, 2, and 3.
Learned additional advocate general for the respondents.
My lord.
The firm of the appellant, which had entered into a rate contract with the respondents for supply of medicines, stands debarred from participating in any future tender for 3 years.
Yes.
Which, according to the respondents, is in consonance with the terms of the contract. It appears from the records that more than 3 items of medicines under the rate contract were not delivered within time, for which a notice was issued to the appellant, intimating him that the products under the rate chart shall be debarred as per the referred penal clauses of the tender if the explanation offered by the appellant was not satisfactory. The other financial penalties also were stated, also would be invoked against him if his reply would not find favor with the respondents. The appellant appears to have replied to the said notice, intimating that because of the logistical issues, the leftover 20% of the supply, 20% of the supply, 20% of the quantity of the drugs. What have I said? 20% of the quantity were not, of the medicines were not supplied. And if the appellant would be permitted 15 days, comma, the same shall be applied, the same shall be supplied to the respondents. However, by order dated but 150. Where is the order of debarment?
155.
$1.
However, by order dated where is the date of the order?
Date of the order, my lord.
However, by an order, however, by an undated order contained in memo E file number 50616/11849-11860, comma, the appellant has been blacklisted and debarred from participating in any tender for 3 years as per the tender clause number 5, which deals with terms and conditions. For 23 numbers of essential drugs. For 23 numbers of essential drugs under the rate contract. The learned counsel for the appellant has submitted that the notice for debarment dated 17/2/2025 did not intimate that if the explanation of the appellant were not found to be acceptable, comma, he would be prevented from participating in any further tender for 3 years. All that the notice indicated was that the products would be debarred. Products would be debarred. Contesting the aforementioned argument, the Mr. Gogoi, learned Additional Advocate General, submits that in the body of the notice, comma, it has clearly been stated that in case the explanations are not found to be satisfactory, the firm shall be blacklisted and debarred from participating in any tender or procuring agency for 3 years. If the company is debarred for all the items where it has rate contract for less than 3 items, or at least 3 items where it holds where the rate contract is for more than 3 items. In case of non-supply and non-satisfactory reply for the same, comma, even the performance security would be forfeited. Mr. Sahewala, however, has pointed out that those are only the penal provisions. These are only the penal provisions provided in the terms of the contract. But so far as the operative part of the notice is concerned, it only referred to debarment of the products and no final debarment of the appellant from participating in any fresh tender for e-contract. It has thus been submitted that the learned single judge, while dealing with the matter, missed out on this and refused to grant any interim protection to the appellant so far as it related to the prayer made on behalf of the appellant that he ought not, that the appellant slash firm ought not to be debarred from participating in any future tender for 3 years. First off. Considering this aspect of the matter, we deem it appropriate to modify the order dated 3/6/2025 to the extent that the appellant would be permitted to participate in the tender for a rate contract, barring the drugs which he could not supply, which could not be supplied for any reason whatsoever. The appeal, the writ petition shall be decided on its own merits whenever it is listed for consideration. The appeal stands disposed of with the aforenoted modification in the order passed by the learned single judge.
Item 15.
Yes, Mr. Mr. Datta,
My lord, it's with regard to correction of date of birth.
nothing, there's nothing. There is literally nothing.
So the
If your date of birth is accepted to be true, then you would have 51 years of service, which is not possible. There is a problem with SEBA. They have not verified the,
no, they have said, my lord,
they did not verify. They said that yes, 67 is the date of birth.
yes.
But if that were correct, then perhaps you would have joined service at the age of 9 years.
Now, that has been treated to be as boy service.
Then boy service or whichever service. Against a
That has-
statute, there cannot be any employment.
My lord,
You were a child then.
my lord, if my date of birth as it is.
Otherwise, forget about boy service or anything. Now, there cannot be 51 years of service.
My lord, if I can place it in other words, my lord, if the date of birth is taken as 58, then on the date of my initial entry, which is being taken by the government now, I become 28 years of age, and the maximum age permissible at that point of time was 25. So that also could not have been the case.
No.
If my lord, 1950.
Who knows? But this cannot be the case at all.
No, my lord, this has been rationalized in view of the endorsements in the service record.
Otherwise, also this is.
My lord,
You've had your stint as an employee for, say, even if 58 and 67, and then you asked for rectification only in the year 2014.
14,
That's 4 years before you were to retire.
yes. Now, my lord, the age that was recorded, if that is accepted to be the correct age, my lord, then my entry into the service becomes when I am 3 years older than the maximum age limit. The rules prevailing at that point of time was 25 years. That was the maximum age. So I could not have been logically and legally entered into service at an age of 28 years. That's why possibly, my lord.
Why?
So
The
25
maximum age was 25.
Yes.
How can that be possible?
Yes, that was the rule at that point
Then
of time.
everybody put a blind eye to your records. But we are not going to allow any further. Mr. Dutt.
At that point of time, my lord, the age was 18 to 25. That was the age prescribed.
So suppose you would have joined suppose you would have joined on December 1, 1967. December 1,
76.
July 31, 1958, you would have been 28 years of age. When
Yes.
did you join service?
My lord, the entry, the records which I
76. In 76, how old would you have been?
28
If your date
years.
of birth would have been July 31, 1958.
It will be around 28 years. And that is why, my lord, this period, my lord, that is.
You have made this argument, but we are not inclined to accept.
In fact, my lord, his lordship, Justice Chaudhary has also delivered a judgment on this aspect of the matter. That under the,
My brother says that he has become much wiser now.
Probably that is why this rationalization was made, that from 76 to 87, this would be excluded from the period of my regular service, and this period will be treated as boy service. That is the exclusion made in the service book.
That'll be tinkering with the law, that would be creating a bad precedent, and we don't allow that. Yes, Mr. Khatiniar,
Yes, Malad.
how do you respond to this submission of Mr. Datta?
Malad, if he,
That suppose you assert that he entered service in the year 1976.
yes, Malad.
Now, if 58 is his date of birth,
58,
the
60,
correct date of birth as you say,
yes, Malad.
then he would have been 28 years
No,
of
Malad,
age.
58, then 60, 10 years, then 76, so 18 years, Malad.
No, no.
Date of birth is 58.
Then in 76.
In 78, he will be 20 years of age, Malad.
78.
Yes, Malad. And he joined in 76. So it's 18 years, Malad, not 28 years, Malad.
How do you say 28?
I'm sorry, Malad. I calculated it on the basis of 1910-87.
No. We have to calculate it from 31st of July 1958 to sometimes in 1976.
Yes, Malad.
1970s, Malad, that date was 15th November 76.
So that ground also goes taken.
Malad, there is another aspect of recovery, Malad. Now, the Honorable Single Judge has also ordered a recovery, and my continuation in service was by virtue of an interim order passed by the Honorable Court, which continued till the date of disposal.
No recovery. No, government should also consider. No, don't recover anything. That was a court's order. If you are satisfied, we must close it now. Mr. Datta.
Malad, that is the only contention I possibly could make.
Heard Mr. S. Datta, senior advocate for the appellant, and Mr. J. Khataniar, N.J. Khataniar for the respondents. The appellant has questioned the judgment dated 4/4/2025 passed by a learned single judge of this court in WPC number 5042 of 2018, refusing to entertain the plea of the appellant that his date of birth be changed to December 1, 1967 from July 31, 1958, which was wrongly recorded in his service book in the year 1976. The contention of the appellant is that his actual date of birth is December 1, 1967, which is shown in his high school leaving certificate from the Board of Secondary Education Assam, bracket SEBA. Thus, obviously, Mr. Datta argues, the entry in the service book regarding date of birth of the appellant was wrong. Taking that very date of birth, namely July 31, 1958, the appellant was made to retire on July 31, 2018, after having completed 60 years of age. The case of the appellant is that he began working at a very early age in 1976. Ultimately, his services were formalized and he was given a temporary status in 1987, in which year only he was made permanent on the post of lower grade assistant cum typist. Prior to his being confirmed, he only served informally as a boy servant, which cannot be counted for his pension or for his service length. It further appears from the records that the appellant tried to have the date of birth corrected in the year 2014. First off, after verification, the SEBA had confirmed that the actual date of birth of the appellant was December 1, 1967. Based on that certification, the service book of the appellant was updated in the year 2018. When the appellant was asked to superannuate, treating his date of birth to be July 31, 1958, he came before this court by WPC number 5042 of 2018. Wherein it was decided that the appellant could not be retired in the year 2018, as his date of birth was certified to be December 1, 1967. Later, a review petition was filed. Later, a review petition was filed in which it was disclosed that the SEBA had cancelled the corrected date.
Well, I am sorry for interruption. It was not cancelled by SEBA. Department had cancelled.
It was revealed that the department had cancelled the corrected date of the appellant for the reason that if the corrected date would have been taken to be the corrected date would have been taken into account, the appellant would have 51 years of service, which was not possible, as a person entering a government job can have a maximum period of 42 years. And that also if he enters the service at the age of 18 years. The appellant also appears to have filed a review petition, bringing on record the details of the documents on which he relied for contending that he was born on December 1, 1967 and not in the year 1958. However, the review petition preferred by the appellant was dismissed, holding that the documents offered by the appellant were of apocryphal origin, which could not have been relied upon. Stop. The learned single judge, however, found that it was absolutely impossible for anybody to have 51 years of service. If the date of birth of the appellant is actually taken to be December 1, 1967, he would have joined government service when he was only 9 years of age, which was not permissible. Considering this aspect of the matter, the learned single judge dismissed the writ petition of the appellant and also directed the government to consider whether the amount received by the appellant by way of his salary after his superannuation in 2018 be recovered. Stop. Though agreeing with the reasoning of the learned single judge regarding the bogus claim of the appellant for claim of the appellant for his date of birth to be changed from 1958 to 1967. July 31, 1958 to December 1, 1967. What have I said? Though we find that any order for recovery of salary beyond 31st of July 2018 would be too harsh a step, especially when the appellant had continued to remain in service on the orders of this court. Thus, we conclude this appeal by holding that the appellant's date of birth was rightly reckoned as July 31, 1958. But there shall not be any recovery from him for the salary that he has received beyond July 31, 2000.
Madam.
The appeal stands partially allowed to the extent indicated above.
Item number 16.
Yes.
This matter has come up for the first time. We have agreed by the judgment passed by the learned single judge.
No, appeal is always first time. You don't expect the court to ask for any counter affidavit in the matter. Everything is on the court. If you're ready with the argument, we will hear you or we will.
Because there's a private respondent, my lord. Notice has to go to the private respondent.
Let's first see whether you can make out
Yes, ma'am.
case.
My lord, may kindly peruse the advertisement which was issued, my lord. That is at page 41.
No, last part, come to the last part of the judgment. The overall judgment. Paragraph 50.
My lord, may kindly.
What has, Mr. Das, anything has happened beyond that? You appear for private respondents.
No, my lord, I appear for respondent number 226, my lord, the High
What
Court.
has happened with respect to the observations made in paragraph 50?
I'll have to get the instructions. my lord.
Take instructions.
Yes. Yes.
We are not issuing notice to any one of the respondents for the reason that the case decides in a different, the case was decided in a different way. Now that accountant would be, the post of accountant would be similar to another post. What is that post?
UDA.
Huh?
UDA.
UDA. But that cannot be an eligibility. That cannot be treated as an eligibility with which we prima facie we agree. We will hear your appeal, but let us first see what has happened after this observation of the learned single judge.
Yes, ma'am.
Yeah. While hearing this appeal, this court noticed the observations made by the learned single judge in paragraphs 50 to 52, which are being extracted herein for the sake of completeness. Then extract this paragraphs. Mr. H.K. Das, Mr. H.K. Das, learned advocate, who appears for response number 2 to 6, to take instructions as to the decision taken by the state of Assam with respect to the observation made in the aforenoted paragraphs of the impugned judgment. List this matter for further consideration in January.
Highly. 9 January. Item number 17.
May it please, Your Lordship.
Yes.
My lord, the matter relates to a mining contract.
Yes.
Now, basically, my lord, what I have challenged before the learned single judge
Yes.
is the approval of the comparative statement. Now, my lord, though no reason has been assigned as to why my bid has been rejected, it is apparent, my lord, from the comparative statement against 2 column, the remark is nil. Possibly that is the reason. If your lordship will kindly come to page 73. Otherwise, I am the highest bidder.
That Mr. Chaudhary, you know the law,
No.
that is not the consideration,
No,
always.
No,
But
no.
you must be given the reason.
yes.
You must be given the reason why
Reason.
you have been non-suited.
Yes, non-suited, yes. Please come to page 73, Milord. On top is my name, serial number 1. I quoted 2 crore and odd. And number 2, Pradeep Basumatre, his thing has been approved. Now, if your lordship would kindly come to that column registration contractor, yes or no. Apparently, there is no. Now, page 73, Milord.
Yes, we are
Yes.
there at it.
Then if your lordship would kindly come to another column, annual turnover, no. Experience certificate, no. So therefore, the overall remark is document shortfall. Now please come to the tender conditions at page 47. Para 30, Milord, towards the bottom of the page. Tender paper must be accompanied with the following documents. Recent passport size photograph, earnest money 10%, no problem. Then PAN, GST registration, bank account, etc. And up-to-date financial soundness certificate. In case the tenderer claims belong to SCSC or not concerned, other information required to be submitted. So, my lord, there is nothing like registration certificate is prescribed. Now, what I find is, my lord, my labor license was not renewed. Other than that, I fulfill all the criteria.
No, but tender form under the Assam minor mineral concession rules.
Yes.
Does it not say that you needed to have an updated, license?
No, my lord.
But that's
issue,
it.
no, doesn't say. There is no, at least tender condition doesn't say so, my lord.
Tender condition doesn't say so.
Yes.
It says that other information required to be submitted
Ah.
as referred to in the tender form of Assam minor mineral
Correct.
concession rules 2013.
Hetu ase nahi. Huh? No, my lord, but tender form says so, but my lord, the mineral rule doesn't say so.
Tender form says so, no? But
Yes.
tender form of my
No,
minor.
Please come to page 55, my lord. This was my tender.
Concession. 55.
Yes. Please come to serial number 5, previous experience, if any. So in case of previous experience on one of the ground on which I was non-suited, that is an optional, is not required. Then of course it says, my lord, towards the below, enclose labor license.
No. This,
Serial number,
that's true, Mr. Chaudhary, we are not agreeable to this suggestion of yours that you are required only to fulfill A, B, C, D, E,
also F.
F.
Also
So
F. I'm not
what-
saying in order.
So therefore the
Minor mineral rule,
forget about minor mineral rules. We are not asking you to go through
Yes.
the format.
No, it's not
The-
that I don't have. What had happened, Miller?
You could have said so, no?
No, I'd say, no, if your lordship should kindly see, my license, last date of submission of bid was 3/1/22. And I applied for my renewal on my lord 20/12/21.
And that's all right.
It was given to me.
You could have filled up this form by saying
Yes.
that this license applied for in 2021.
Yes.
You could have said that.
Question nahi.
You have left it blank.
No, I kept it blank. No, my lord, now, on the contrary, let us come to respondent number 8's
No,
part.
but
No, kindly see me, lord.
Mr. Chaudhary, we will hear you.
Yes.
Not that we don't
My
short
lord,
circuit it.
my prayer in this case is there should be a retender because till they have not done anything. They have not done anything. They have not finalized the contract. Why I'm saying so? Last date was 3/1/22. Kindly come to the two most important document of respondent number 8 at page 150.
Mr.
150, my lord.
The
For a
difficult,
moment.
the difficult, yeah, we will come to that. We'll have to overcome this hurdle.
Yeah.
That for looking at the tender form of respondent number 8,
My lord,
you need to first say that you are a rightful tender who has wrongly been rejected.
correct. My lord, my humble submission is as far as renewal is concerned, I have a vested right of renewal. The renewal I got. I applied on 21/12.
This information was missing there.
It is not there, but they could have sought for an, clarification, which they did not do. So for a moment, please come to page 150 and 151, Miller. And before finalization of the contract, we have intimated, Miller, regarding my license. Now kindly see solvency certificate, it is dated 31/1/22 and the last date was 3/1/22. How they took note of this, Miller? Then please come to 151. Experience certificate. This is dated 1/2/22. Last date was 3/1/22. And my lord, I intimated them regarding my renewal before finalization of the approval of the CS. Because I got the intimation on 4/3/22 at page 76. Page 76.
Therefore, the experience certificate also, they have said no.
No, therefore, my lord, therefore, what I am suggesting is, subject to what your lordships may say, the records would reveal the actual position, my lord. How there his case, respondent number 8's case was assessed and how my case was assessed. Because had it been a case where award of the contract had taken place, things would have been different. Now, my lord, there is no award of the contract. The matter stands where it is.
Vesting has not been given.
Yes.
Vesting has not been given, but once.
No, my lord, only comparative statement was approved, nothing beyond that. Because I laid a challenge at the stage of when the comparative statement was approved at page 79. My challenge was against page 79.
Page 79.
Yes. With reference to the above, I am directed to inform you that Boroland Territorial Council is pleased to approve comparative statement to settle this so-and-so, so-and-so for granting of a mining contract of successful bidder, so-and-so, so-and-so, so-and-so. So this was the challenge below. So nothing has progressed beyond this stage. Now, my lord, I also actually do not know, my lord, I am just inferring. Possibly this could be the reason. That number one, that my
You
level.
have been intimated about the ground
No,
of
no, no,
objection.
no.
Yes, why don't you give MS Bhuya?
Lordship, this is a comparative statement, Lordship, annexure 13.
Comparative statement is all right.
Yes, it's a 2022, the
Comparative
Lordship.
statement is all right.
Yes, my lord.
But then you're supposed to inform,
My lord.
you're supposed to take out that decision that so-and-so bidders do not qualify technically.
On
Lordship.
such and such ground.
I'll take instruction from, because we have been newly engaged, my lord, in the BTC. Lordship will take instruction.
A matter which could be decided, now you're asking for instructions, what do I say?
This latest position is not known, your lordship.
My lord, my humble submission is
Question
subject.
is this,
My lord,
now, he was not informed about anything.
he said his submission is that.
No, because,
You don't have any document to dispel that.
no, because page 79
And he-
doesn't say so anything.
He has challenged only page 79.
Lordship.
The acceptance of the comparative statement.
Yes, my lord.
For settling the issue.
Yes, your lordship.
Then would he be justified in asking for a reason? Now, this is a reason which he conjures up himself because there were two things. I mean, maybe there was some disclosure by the department when contempt matter was being dealt with.
My lord.
But then that reasoning must be there. No? To that extent, file your response.
Lordship.
Take that. But then we are not staying the vesting.
No, my lord, I'm not, because Lanet single
Number
judges,
eight,
before single judge also nothing. No, my lord, my instruction is, my lord, they have not moved forward. The matter is as it is very.
Even if they would have moved forward, we would not have stayed. Take them. The respond number 6 / Divisional Forest Officer, Parbat Chhora Division, Supari Ghat, District Kokrajhar, Assam. Issued a sale notice on November 29, 2021, inviting tenders for mining rights under the Shimul Tapu Minor Mineral Unit under Parbat Jhora Forest Division. The appellant, along with others, participated in the bid by submitting their tender along with the required documents and the earnest money. The tenders were opened sometimes in January 2022. And it is the claim of the appellant that he was verbally informed that he was the highest bidder. However, no formal comparative statement was issued or published at that time. And therefore, no award was there was no award of contract in favor of any one of the bidders. For this delay in finalizing the issue, the appellant had approached this court by WPC number 3189 of 2022, which is stood disposed of with a direction to the respondents to finalize the decision within a period of 3 weeks. After the passing of the aforenoted period within which a decision had to be taken, the appellant preferred a contempt petition, by contempt case number 401 of 2022. While responding to the contempt petition, the respond number 6 made a disclosure before the court that the bid of the appellant had been rejected for shortfall in the documents in his tender paper. Which included a valid labor license and experience certificate required of the bidders. With this disclosure, the contempt petition was closed. Thereafter, Mr. Chaudhary, learned senior advocate, has argued a comparative statement was issued on February 27, 2023. Which was challenged by him on various grounds, including that the shortfall documents were not necessarily to be filed at the time of filing tender. The other ground of challenge was that his labor license had expired in October 12, on October 12, 2015, for which a renewal application had been filed by the appellant on December 20, 2021. But the license was renewed only on 4th of March 2022. That is after the filing of the bid by the appellant. Apart from that, it was submitted that the experience certificate was also not mandatory. And if it were, it was curable as there was no prescription in the tender documents of accepting any required document later than the bid filing date and before the finalization of the contract, before the decision regarding selection of the bidder, selection of the successful bidder. To the dismay of the appellant, respondent number 8 was selected as the successful candidate, as the successful bidder. Notwithstanding his low offer and his bid form also not containing necessary details for which the bid of the petitioner appears to have been rejected. Lastly, it has been submitted that the petitioner, appellant. Lastly, it has been submitted that the appellant was not served with any notice of his having been technically disqualified. No, notice, he did not. Lastly, it has been submitted that the appellant was never notified of his having been technically disqualified in the tender for want of documents, for want of necessary documents. Thereby not giving him any opportunity to explain the reason why there was a shortfall of the concerned documents, if at all they were required to be necessarily filed along with the bid paper. MS B. Bhuyan, learned senior, yeah? Learned senior. What is senior? An official key representative?
Standing Council BTC.
The MSB Bhuyan, learned Standing Council BTC, seeks some time to take instructions to the matter before addressing this court. Let this matter come up for consideration again on sometimes in December.
8 December.
Develop.
No.
Item-
We'll come back up. Yeah, come back up. Kitna matters the check?
8 minutes.
We'll come back. Yes.
Item 18.
Yes.
May it please lodge, because the minor penalty of recovery against the storage losses was imposed, that was put to challenge.
Hmm.
The learned single judge has interfered with the order on the ground, basically, that the procedure laid down under Regulation 60, which says that there should be a finding against each of the charges, number one, it is not there. And secondly, the order is also doesn't reflect directly any imputation against the petition. Lordship will kindly have a look, the appellate.
Yes. Yes.
My lord, this contention of the petitioner, when he filed the appeal, the appellate authority has made a relook of the everything and passed the detailed order. Lordship kindly see page 159.
1 second. Well, give us 1 minute. We'll just see the order.
Two 241 is the.
Yes.
My lord, in case of minor penalty for recovery against losses,
That's right, we have read that.
my lord, detailed procedure prescribed under if is not recurred. You know,
But
that is what
tell me
the
one thing, Mr. Singh, Mr. Roy,
lordship.
uh, is it not presumptive?
My
There was
lord,
a shortage. Shortage was more than in the previous years. Agreed. Now, what about that 2008 circular? Number one. Number two, even for minor charges under regulation 60, the finding had to be there that he did not behave himself as an officer. He was negligent because of his wrong, record keeping.
Lordship-
All this happened.
lordship is
Pilferage.
lordship is wrong.
We get to
My lord, what happened after the impugn order has been passed by the disciplinary authority, he preferred an appeal. The appellate authority had made a relook of everything and passed a detailed order, 159. Taking into consideration all the evidence and after giving personal hearing, 159, my lord, kindly see relevant at page 165.
165.
Is the relevant finding, my lord? He cannot escape this liability, my lord. That is what the, and taken into consideration every material on record. That is a norm, a standard norm,
Where exactly do you want us to come?
page 165 and the paragraph, my lord, last but one, and whereas, lordship got it, my lord.
Yes.
And whereas it is thus an admitted position that Sri Ankit Kumar was the shed in charge and shed number so and so, May 2004 so and so respectively. And the zero physical verification was conducted both in the sheds during this period. It is an admitted position that out of 38 stacks issued in shed number 5 during zero PV, at least 20 stacks were formed during the period so and so, and 20 stacks alone, shortage of or so and so quintals of rice was found during zero PV and was unjustified loss to the tune of so and so, at least which Sri Ankit Kumar cannot shun his responsibility. As per the norms prescribed, justified unjustified storage is calculated based on 29.10 pro forma, which is based on the period of storage, reduction, moisture, the value of the unjustified loss, and so is also. Now, my lord, there is a norm prescribed, but the storage loss is caused for different reasons.
So we understand this. Out of 38 stacks, stacks means sacks.
Stacks means gives us
38 stacks. There were only 20 stacks.
lordship. So it is during his tenure. He is the shed in charge.
That's all right.
Shed in charge and will not miss,
but,
if it is storage loss.
Where is the proof? Where have you tried to
My
prove
lord,
that it was
my lord, it
pilfered?
happens like this for this storage loss. It requires no detailed procedure to go into proof and everything because my lord, kindly regulation 60, if your lordship kindly, and this is upheld by the Supreme Court in Prahlad Rao's case. Lordship will kindly have a look at this.
Stacks is the
Yes.
number of bags
Now, my
in
lord,
one stack.
my lord, may I explain, my lord?
What does it mean?
It happened like this.
Read this paragraph again. And whereas it is thus an admitted position that Ankit Kumar was the shed in charge of shed number 4 and 5, so and so respectively, and the zero, what is PV?
Physical verification.
And the zero physical verification was
Means 100%, my lord.
conducted in both the sheds. It is also an admitted position that out of 38 stacks issued in shed number 5 during zero PV, at least 20 stacks were formed during the period of, I don't understand, 20 stacks were formed, 20 stacks were issued.
No, 20 stacks were
made. 20
During
stacks
he
were
is shed
made.
in charge.
In which shortage? So
He is shed in charge.
tell me one thing. We have followed, he's a shed in charge.
Lordship.
But then was there any, I mean, these stacks would include sacks. So it was just the storage loss, no?
No, that's, your lordship is right. My lord, in fact, when storage loss occurs, it is impossible, my lord, to find out the exact culpability because there is a standard norm.
Aren't you answering Mr. For him? If it is exactly impossible, would you?
No, my lord, no, my lord, it happened, therefore, my lord, as my lord, specified norm is fixed. Storage loss is caused for various factors, like when moisture content rise and various other factors.
You know,
So, my lord, the standard norm is 0.05%. If it goes beyond that, that is abnormal.
But
that is abnormal. That is
right. It's abnormal.
lordship.
Loss of 249 quintals would not be because of, we understand that. Mr.
There has to be, my lord, there has to be a human factor.
Mr. Roy, probably we are not clear to you. We understand that there could not have been a storage loss to the extent of 249 quintals. Cannot.
Unjustified.
Humanly impossible.
Lordship. Unless.
Where is the evidence that there was pilferage? Where is the evidence that the sacks in this stack were eaten or not eaten by rodents? Where is the evidence that he, because of his lack of diligence, stacks were taken away? That's what we are asking.
Lordship is right. The authority found no evidence of storage, I mean theft, pilferage, and rodent problem. And therefore it has to be because that's how, my lord,
that's how you presume. Reverse burden. Are you suggesting reverse burden?
My lord, it is because he is the
And you're asking him to pay 18 lakhs.
No, not him, my lord. He was only that was reduced, my lord, because
18 lakhs in 12 monthly installments.
1.8 lakhs.
1 point.
What's your 1.8 lakh?
1.8. But it was equally distributed amongst all the staffs, my lord. Not him alone. Not him alone.
Now read this circular. You
My
will
lord.
find it at page 242.
My lord.
Come to page 242. Internal page 14.
That I understand, my lord. That is a circular, my lord. That is a, my lord, between the labor union and they raised an objection. That doesn't form part of the, my lord, rule. Because in fact, that is a word like, my lord.
This is a circular issued by you.
No, that's right. My lord, the circular also said.
What has happened to other employees who have been slapped with this kind of notice, with this kind of fine?
My lord, everybody has been who are in that go down.
That's right.
Yes.
What happened to their appeals?
They are pending, my lord. Some are pending. Two more are pending, my lord. That is listed. 2 more are pending.
Where is that?
That has not been listed before, Lord.
It will be listed. We'll hear it together.
Lord.
Otherwise, prima facie, we are not inclined.
Lordship,
We are not inclined to interfere with the single judge's order. Prima facie. But then, Mr. Gupta, don't be happy for the reason that it must be accounted for. It is not a storage loss. So whether this presumption can go against you, but we can't give you a clean sheet and leave others.
May I submit before Lordship?
Yes.
My learned friend.
We would like all this to be heard together.
Yes. My learned friend has not been able to answer your queries.
Mr. Roy has answered. That has not satisfied us. That's another reason.
Pointed queries regarding it. How many people? My client is Ankit Kumar's case is he was said in charge of cell number 1 and cell number 4.
4 and 5.
4 and 5.
4 and 5.
4 and 5. Yes. So what happened? This man was doing in said number 4. The loss is 0.44%. 0.44% is the lowest amongst all the sales, whatever he was earning. In said number 5, he was asked without any formal office order, without formally taking over the charge of said number 5 in sometime in June, 11th of June, 11th of May, he took charge without any formal handover. Prior to that, I will tell the history of this. In February, one Mr. Buddheshwar Saikia, he was said in charge of
said number 5. After his retirement in February, for 1 year, 1 month and 20 days, there was no said in charge. And this gentleman, Ankit Kumar, was asked to take charge on oral orders to take charge of the said number 5. When he joined cell number 5, he found so many irregularities. Immediately he sent a letter to the higher ups.
So now the record. Give us the numbers of
Well,
those accounts.
the only delay has been condoned number. It is not numbered yet. The Lordship, I can give the details, filing details. That can be. This is in fact the first one, amongst those 3 appeals.
One
Take that. We have heard Sri P.K. Roy, learned senior advocate for the Appellant Corporation of India, and Mr. G.K. Gupta, learned advocate for the respondent / Ankit Kumar. The appellant / FCI has questioned the judgment dated 18/12/2024, passed by a learned single judge in WPC number 4606 of 2023, whereby the fine slapped on him for rupees 1,80,000 to be paid within a period of 30 days. 1,80,000 to be paid in 12 monthly installments has been interfered with. And it has also been directed that the petitioner be not penalized so far as his promotional avenues are concerned by resorting to the sealed cover procedure with respect to his promotion to the higher post. It appears that 249 quintals of rice was found short in 2 of the sheds of the Food Corporation of India, of which the respondent was in charge. Though initially it was proposed to subject him and others responsible for such huge losses to a departmental proceeding for major penalties, but on perusal of his explanation, it was decided that the respondent be proceeded under Regulation 60 of the Food Corporation of India Act.
Staff regulation.
Food Corporation of India staff regulation meant for minor penalties. The disciplinary authority found that the respondent was to be blamed for the unusual losses of 249 quintals of rice, which could not have been attributed to storage loss, and therefore he was slapped with a fine proportionate to his guilt to the amount of rupees 1,80,000 as referred to above. However, in appeal, the same order was sustained, though with a stronger reason indicating as to how the assessment, as to how the losses detected could not have been attributed to the storage loss. The learned single judge, after having gone through the entire records of the case, more particularly the circular dated 12/2/2008 issued by the respondent authorities, preventing the holding of officers or employees of FCI to be responsible for storage losses, and there being no material disclosed during the departmental proceeding that the loss was due to any fault on the part of the respondent, set aside the original as well as the appellate order holding the respondent guilty to the extent of his liability. This court has been informed that several other persons were proceeded against who have been slapped with.
Two other.
There are two other persons also. Yeah, whatever. This court has been, during the course of hearing, this court has been informed by Mr. Roy, learned senior advocate appearing for the appellant, that two other persons have also been found responsible for the losses referred to above, and they also have been saddled with fine and whose appeals are pending consideration before this court. Let this case be listed along with the aforementioned appeals. Give the numbers on so and so day.
One number I got with me. W eight 297.
You'll give it to him later, on a piece of paper, don't dictate it. On so and so date, January.
297. Pramod Pradeep Kumar.
Deep blue plus.
Item number 20.
Might please your watch.
Yes.
Well, the question is whether the learned single judge was right in
Yes.
declining an interim order as was prayed for in the given fact situation of the case. Kindly see. The learned single judge
Can you
was
give us just 1 minute, Mr. Mohanty?
mine.
1 minute,
Yes.
1 second. Please take your seat, we'll call upon you.
Yes.
Please sit down. The interim नहीं देता ना, लेकिन it is subject to the. It's declined. Whether, Mr. Mohanty, whether confirmation of those persons on service or not, would it make any difference if your case is allowed?
Well, yes, well, the question is, it will
You'll have
at
to
least
make
pave
them
and way.
Otherwise also you'll have to, even with their non-confirmation in service, you'll have to make them a party.
They are made parties.
They are parties.
They are parties. They are parties. They are parties. At least,
Argue out your case.
sorry.
Argue out your case before the learned single judge. The final, I mean, they would undergo training. But
They are undergoing training.
finally one of them will have to go if your case is allowed.
Maybe.
So therefore. it's
That's
not-
why, Malad, what we are asking for an innocuous order. No, now they will not be affected, but then it will make a provision for consideration of this honorable court. If at all it is found that yes, I deserve to be appointed,
So one will
then
go-
how to take the call?
Now, the call will be taken by the respondents. By
Therefore-
force, they will have to take the call.
Therefore,
They will have to remove that person who has
Exactly.
scored lesser marks than you. Finished.
exactly. Malad, therefore, what we
No, an
want,
interim order could not have been passed.
Malad, Lordship,
For deciding your case, their confirmation could not have been delayed. But we will say that the end result would be the same. You would not be put to any disadvantage because of no interim order.
my lord, Lordship understands this very well, that interim, what is the purpose of an interim order?
Here it is not required.
To preserve the position as it is today, so that tomorrow there may not be any difficulty. That's the only, and what we are asking for. We are asking for, they have been meanwhile
You're asking,
appointed and they are to be confirmed.
according to them, the other persons who have been selected, according to them, you are asking for moon, nothing less than that.
Asking for moon.
Asking?
For a big thing, you're asking for moon.
Well, may not be.
And you might start asking for stars.
My lord, it is within the reach of this honorable court.
I don't think, Mr. Monto, you should be under any apprehension that even if you succeed, because of the passage of time, your case would end in becoming infructuous. No.
My lord, why I'm saying, experience shows that after a period of 2 years, 3 years, we do not know how much time it will consume. But then it takes the.
No, we will say that this matter be expeditiously heard. We will make a request. Then
And Lordship may say.
we will make a request to the single judge to expeditiously hear.
That will be a great step, my lord.
Take note.
I also pray one thing.
Yes.
Lordship may say, because here is a case where the delay is not attributable directly to me. I am not liable. Personally, there was nothing on my part.
That's right.
So,
But
the learned single judge to
But
give
tell me
you.
one thing, why do you want to become a forest ranger if it were not for only illegally felling of trees? You're a chemical engineer.
Well, sir, people are having taken the degrees, looking for opportunities to get employed.
It's like a lawyer trained under Mr. Mohanta trying to take a license under the public distribution system for running a kirana shop.
Malad, at least till now, that has not happened in case of the lawyers.
Your junior is not very happy with this comparison.
Definitely, at least in my experience, lawyers have not gone to that extent till today. They could have, because
No,
they take this challenge.
That has got nothing to do with the merits of your case. This was a lighter way.
Exactly.
But then we request the learned single judge to give you an expeditious hearing.
And my lord, Lordship may see, because we asked for the till returnable date, at least you pass an order so that they will come up with.
Principally, we are not inclined. On principle, we are not inclined for the reason that suppose you succeed, you elbow out only one.
Yes.
Why should others, and who that others are, we don't know. Why should there be any delay in their confirmation of service? That's the reason.
My lord, those are the issues which will require threadbare discussions. I can place before your lordship that it was their failure, commission's failure to provide those marks. They say they took resort to RTI Act.
Mr. Mohanta, you have understood our reasoning. Our reasoning is that assuming that you succeed, one person will have to go.
Yes.
If one person goes, why keep other 6, in limbo?
At least lordship may leave.
How can we say that? Who is that one?
They have not come up with. So
therefore, let it be decided.
So lordship may say that immediately on filing of the returns, the matter may be decided.
Yes, we will make that request. We cannot direct, we cannot
True, my lord.
The learned single judge is just like a judge, one of us. Only because we are sitting in division,
exactly.
We don't wield bigger powers. We can't direct them. We can't direct him. We will make a request. And I'm sure that it will be adhered to.
I have to make a request. And despite those requests at times, because of so many factors, not that the
let us see whether our request is accepted by the secretary.
And APSC may immediately file their counter.
We have heard Mr. K.K. Mohanta, learned senior advocate for the appellant, and Mr. P.J. Mohanta, learned senior advocate for the correspondence number 3, 4, and 5. Correspondence number 3, 4, and 5. It is the case of the appellant that he had applied under the EWS category for being appointed as a forest ranger in Assam Forest Service, in which he has scored 419.75 marks, which is much higher than the cutoff marks for the EWS category, which is 397. Nonetheless, he was not appointed, semicolon, rather appointment letters were given to others in that category. The final select list, according to the appellant, does not disclose the marks obtained by the selected candidates, thereby making it absolutely opaque, arbitrary, and unfair, more so when the appellant, through the mechanism of right to information, through the mechanism of RTI, has come to know that he has secured much more marks than the cutoff marks fixed for the category of EWS. What the appellant is aggrieved presently is the refusal of the learned single judge to direct for staying the confirmation of the service of respondents number 6 and 10, respondents number 6 to 10, who have been selected in the recruitment, who have been selected in the recruitment process, who have been selected, who have been who have been declared to be successful and have been selected in the recruitment process referred to above. We are of the view that even if the case of the appellant succeeds finally, only one person out of respondents number 6 to 10 will have to make way for accommodating the appellant. Under such circumstances, it would not be appropriate, it would not have been appropriate for the learned single judge to have directed for not confirming the services of response number 6 to 10. Precisely for this reason, the stay prayed by the appellant was refused. We, in all fitness of things, deem it appropriate to dispose of this appeal by making a request to the learned single judge to give the appellant an expeditious hearing, directing the respondents to file their affidavits without delay, preferably within a period of 3 months. The appeal stands disposed of accordingly.
Item number 31, there is one hearing matter today.
Yes.
I have some personal difficulty in the second half. I have informed the other side also. Would it be on some other day, Lord?
We bring it on January. Keep it.
There is, I don't think there is any urgency.
My lord, urgency is there, my lord. Still people are being pushed back, my lord. A lady, my lord, who has been pushed back is now in behind the bar in Bangladesh, my lord.
No.
My lord.
Pushback is something else.
My lord.
Person being sent to Bangladesh is something else under a procedure.
No, my lord, they are saying that the pushback and deportation is the same meaning in their affidavit, my lord, which is not at all correct, my lord.
Anyway, we'll see it in first week of January.
My lord, kindly on some date is urgency is there, my lord. People are being harassed, my lord. Pick
December.
up, my lord.
Again, let this matter come up for further consideration on
11 December.
on 11th. Before
16
Fixing a date, sir.
16 December.
Could it be on
Silver
Lordship,
Const-
or the previous week, Lordship?
All right. When both of you want it in the previous week, we'll give it in the previous week. 11th, all right, 11th.
11th of December, my lord.
11th of,
Deeply obliged.
My lord.
11th of December. Now, how many matters? Okay. We'll
Obliged, my lord.
Deeply obliged.
Yes.
Item 21.
Advocate का नाम दे दिया करना. Yes.
May I please your lordship? Lord, in terms of the direct liberty granted by the small court, my lord, in page 97,
Is 107?
regarding my lord, granting permission of lotteries, my lord, on the eve of festivals, my lord. Initially, there is a interim order restraining the government, my lord. Then we file application for modification. And in that petition, your lordship passed this order on page 97.
Is the same. Same out, same out, page 97. उसी petition में हम लोग लिखते हैं. All right, the final order was passed, which you have annexed at 107.
No, this is my lord, some my lord applicant approached the department, my lord, they rejected. Then they challenged this rejection order. Then your lordship passed this order, remanded the matter.
In
Our
terms of
case,
the
my
same
lord,
order.
our application has not been decided till date.
Then we.
So, my lord, our
So the
Our-
appeal shall be considered in terms
yes,
of
my
what we
lord.
say like.
Yes,
this.
our application, or we will file my lord, fresh application. We will file fresh application, my lord,
All right,
and lordship.
in terms of that order, dispose. of.
Lordship.
Yes.
Deep level.
Give you the same liberty.
Lordship.
Same order. no?
Item 23.
Here it is.
May I please your lordship? Lordship, I'm appearing on behalf of the defendant number 1. Lordship, we are supposed to file our reply to the IA, Lordship. Lordship, I humbly pray for 2 weeks' time to file our reply, Lordship.
Time is running short for Mr. M.K. Chowdhury.
My lord, let them take short time, my lord, shorter
I
time
was
because
prayed
of.
for on behalf of respondent number 1. Let this matter come up for consideration on December 2nd week,
My lord, that will be too long, my lord.
November last week.
Deeply obliged,
Shorter, my
Lordship.
lord, little shorter.
10th November.
Shorter would be November the 2nd week.
I'm obliged, Lordship.
10th November.
My lord, only apprehension is that, my lord, I may lose the job which I am, my lord, holding for the 2.5 years.
Second week of November.
Or your worship may grant, my lord, status quo till that date, my lord.
Lordship, he's still holding the post of principal in spite of the order.
Let's see, let's.
Item 24.
And
My lord, in this case, my lord, in pursuant to the last order, that is 26/3/2025, they have to apprise the court by filing a affidavit regarding latest position of the, my lord, eviction. It's a government land, my lord, allotted to the defined government department.
Shows the last order.
Last order dated 26/3/2025.
Orders.
26/3/2025.
Can't handle like this.
It's a very, file is very bulky now. 26/3.
So the latest factual report,
Yes.
My lord.
May I please, Your Lordship?
So-
I have received the latest updated status report regarding this case, Your
Bring it
Lordship,
on record.
today morning,
Bring
Your
it.
Lordship. I may be granted 2 weeks' time to
in Bordoloi.
file my affidavit.
You are in Bordoloi,
Yes, Your Lordship.
MS N Bordoloi, London Standing Council bracket Revenue. Submits that she has received instructions with respect to the latest report regarding removal of encroachment on government land, which she will put on record by the next date. Let this matter come up for consideration again on your date in January.
Deeply.
7 January.
I'm deeply obliged, Your Lordship.
Item 25 and 26.
May I please, Your Lordship? I am appearing in item 26, Lordship. Morning also I saw.
Who appears in item number 35?
I am minus 25, my lord.
She wants an adjournment in item number 26.
Yes,
Both of the cases shall be taken up together.
yes.
My lord,
Week time may be,
I played, my lord, my pleadings is completed, my lord. So, my lord, on the short date may be given because, my lord, there is urgency in this.
She is not asking for a long date.
I'm also.
Like here. As prayed for, you are making a mention in PIL 74 on behalf of respondents.
Petition.
Like here, what is the name? What is your name?
T-Som.
MST Som. MST Som, learned advocate for the petitioner in PIL number 74 of 2023. Seeks an adjournment for filing an additional affidavit.
Reply, Lord.
For filing an additional affidavit by way of reply in the matter. Let this case come up for consideration on 17th of November. Stop. Let WPC number 5572 of 2023 be also listed on the same day along with the aforementioned PI.
Much
Obliged, Your Lordship.
Supplementary list for admission, item 33 to 49.
और हमारे देश में भी बीच में कोई लिखना था जिसमें नायक वगैरह नहीं उसको देख लेंगे मैं अभी पूछ लेना नायक से कि उसने दिया नहीं तो हम लोग उसको डेट पर लगाएंगे किंतु उनको होगा मुस्कान भी करते हाँ तो पूछ लेना कि is he here now? Yes.
Lordship, in this series, Lordship, in some of the cases, most of the cases, service report is not there. Let the registry verify and submit, or I have to take fresh steps because only few cases the service is complete. And in one case, my friend appears, Lordship, 1 or 2 cases, Lordship.
I am appearing in Lordship, most of the cases, Lordship, except a few, I'll be appearing, but I have filed wakalatnama in item number 33, 34, 37, 43, 45. For about
Mr. Tabindar, you do one thing.
Lordship.
You let us know
Lordship.
whether you are appearing for all the respondents in all the matters.
Yes, Lordship, except item number 38 and item number 46.
Except item number 38 and 46.
46.
Can you seek instructions from the clients?
Lordship.
Whether you will, 46 is already there. So 38 only.
No, Lordship, 38 and 46.
46 somebody is appearing.
Yes, 46.
So 38.
38. In this series.
इसमें कौन है? Petitioners कौन है?
Otherwise, Lordship.
Mr. Tabildar, can we request you to take instructions with respect to item number 38? Whether you would represent the respondent in that case also?
No, in this matter, Lordship, actually, I was not the counsel in the before the
Inform the council who had been appearing in this matter.
Lordship.
that this case is waiting, I mean, it is, the decision is being awaited only because of that. He must appear, no?
Yes, I'll inform Lordship.
Please let him know and then we fix a date for final hearing.
Yes, yes. Otherwise, Lordship, the
Pleadings are complete otherwise.
yes.
No, only few cases, 1 or 2 cases he has filed.
Lordship, only one case I
Academic.
have filed because Lordship, the issue here involved is
Mr. Thavindar, please be specific. We don't
no,
want
not required.
reasons.
Not Lordship.
If you say that in all other matters, you would follow the same,
Yes, yes, not required, Lordship.
not required.
Only law
Good
will,
enough.
law, settled law is there.
Therefore, it is right for hearing,
Yes.
except 38.
Stand taken by the respondent in one of the matter, I'm not representing. I want to go through the affidavit. What is the contention made by the him? A copy of that affidavit. may be
I
served
have,
on the-
I have
asked
already
the
served to the, I have already
Then
served to the.
तुम्ही ना होतं like DJ Sharma. Okay.
No, he-
I have served police, I have served.
No,
Give the copy to him also.
Yes, I can, as because.
I can know. You must.
Yes, Lordship, yes, I will, because Lordship, because I have served the copy to the learned ASDI Lordship.
GSG.
He is appearing in the case, so I have not served him.
In most of the matters, which have been listed analogous, Mr. Tabildar appears for the respondents. Stop. There is no representation on behalf of the respondent in item number 38. Namely so-and-so, give the name of the case. Mr. Tabildar has offered, a learned advocate has offered to let the advocate who had appeared in the writ petition in that case, who had appeared in the OA in that case before the tribunal. What have I said? Know about this case. Otherwise, the pleadings are complete with respect to all the matters listed analogous. Let all these matters come up for hearing give a date in January for hearing and final disposal on so and so. All right. Give a copy to him.
Lordship,
22nd January.
otherwise, Lordship, the issue has already been settled by the Honorable Supreme Court and Delhi High Court also in a batch of petitions. Obliged, Lordship.
Then we keep it only, I mean, this year only.
Lordship.
Then we keep all these matters this year only if everything is
Yes,
decided.
Lordship, already settled by the Honorable Supreme Court, number of judgments, a batch of petitions, I can give the numbers also, judgment also, I can paste, Lordship.
December.
December.
2nd December.
2nd December.
Second December.
Obliged. Lordship, 2nd December, it will be.
2nd December, I'll not.
Let it be in the January itself.
No.
The earlier date was.
Second holiday as well.
Or let it remain in January.
Yeah,
22nd January.
22nd January. Lordship. Obliged, Lordship.